Hello, I'm Molly Blazek, and I wanted to personally thank you for your purchase on Guardian Connect's EDU platform. The information you're about to receive in this webinar is one of my favorites. I hope you enjoy. So without further ado, let's start talking about enable accounts. And just generally speaking, enable is, well, actually, that's my first mistake. Don't keep a tally. Enable is what Nebraska refers to as their adoption of the ABLE Act. So the ABLE Act is a federal act that's the Achieving a Better Life Experience Act that was enacted in 2014. And it is meant to provide tax-exempt savings accounts for qualified disability expenses. Now, it's a lot of words to digest. Essentially, the act has now afforded disabled participants an opportunity to save money that they wouldn't have been able to save before without disqualifying them from means-tested benefits. Think like SSI or Medicaid. And if there was no way to save it, what they were constantly having to do is spend their money down. I'm sure that the guardians who are joining me understand that word all too well. Had to spend money down, you have to spend money and get rid of it so that you can stay under these thresholds. For SSI, it's $2,000 at any given time. For Medicaid, it's $4,000, and it's the lesser of the two. So if you're dual enrolled and you have a participant who is on SSI and Medicaid, you can't get above $2,000 no matter what. So each state, and not all states participate in the ABLE program, but each state that does, and a majority do, they have their own name for the ABLE Act. In Nebraska, we call it Enable. I've seen the account called Stable. I've seen iAble. So everybody kind of has their own acronym, but it's all linked to ABLE, which is the Achieving a Better Life Experience Act. Nebraska adopted Enable in 2015, and since then has been providing those with disabilities the ability to save money that they otherwise would not have been able to save. The really nice thing about these Enable accounts is that the earnings and the distributions are tax exempt. Enrollment in Enable is really, really easy. And there are some limitations on what types of surrogate decision makers can enroll on behalf of a participant. But generally speaking, those who are eligible are people who are disabled or are blind, and the onset of that disability or blindness was prior to age 26. If those individuals don't have a surrogate decision maker, like a guardian or a power of attorney or a conservator, they would be able to enroll in this program individually. For those who would have a surrogate decision maker, like a guardian, the guardian can enroll on their behalf. And how you do that is just through their online forum. And I have a link on the screen. I've made a tiny URL to the website where you can go and check out how you enroll. And here's my second mistake. There is a difference for how surrogate decision makers enroll in this program. An individual is permitted to use the online application, but a guardian or a conservator or a POA is required to use a paper application. And that's primarily so that you can send in your documentation to demonstrate that you have authority to act on behalf of the person. But this link that's on the screen is something that you should jot down so that you can go peruse the Enable website, which again is Nebraska's application of the act. And you can get a lot of information that's really, really easy to understand at that site. One last thing before I move on is that I mentioned that you must be disabled or have the onset of your disability or blindness be prior to age 26. There is an age adjustment act that hasn't passed, but the intention of the act is to try and make it so that the age gap would be from not 26, but 46. And that would be an incredible thing, because when I was talking to Diane Stewart yesterday, who is the outreach program specialist for Enable, She said that that would help something like 8 million Americans with disabilities. And so that's no small number to increase the age adjustment from 26 to 46. So the checking and the savings account operate substantially similar to how all of our checking and savings accounts operate. They're FDIC insured up to the traditional limits. With a checking account, you can use a debit card or you can use a checkbook. Savings account, you can obviously make deposits and withdrawals, but it's not going to be the same for frequent transactions like it would be in a checking account. One of the questions that we received in advance about Enable accounts in general was why the account isn't insured. And I'm not sure where that information comes from, because in our research and my understanding is that it is FDIC insured. And similarly to the fees that we're charged to have certain types of accounts, including, I think more and more checking accounts are now requiring service fees unless you do something like online statements or keep a certain balance to waive the service fee for the month. It mimics those types of transactions. And part of the question about asking whether or not the checking or savings account were FDIC insured also asked what the purpose of the fee was, and whether the fee seemed to take advantage of the disabled participant who was enrolled in this program. And I know as guardians, we have to be vigilant in protecting our wards from things that are meant to take advantage of them. With respect to the fees for the Enable account, I guess I don't take that view. I think that in contrast to the other opportunities for a disabled person who is on government-based needs-based benefits, this would probably be the lower cost option. The only option, and I don't want to get ahead of myself because I'm going to talk about this a little bit in a different slide, but the only other option for a person who is on SSI or on Medicaid to save money, if it's their own money, would be to put it in what's called a first party supplemental needs trust. And when you have a trust, you have to have a trustee. If you can have a family member serve as a trustee or a family friend, that's excellent. They may do so without charging anything. But a lot of times we see corporate fiduciaries serving in these trustee roles. In fact, I'm sure that some of you, if you have trust planning, you probably have a trustee and then you have a successor trustee that's within your friends and family, but then there'll be a third, and it's usually a bank. And when banks are charging to administer trusts, it's going to be more than what the cost annually for an Enable account is. I think, JT, isn't it $45? For the checking and the savings account, the annual fee is $45 a year. Are you nodding your head yes? Okay, he's nodding yes. Now, for the investment options that he was talking about, that's a little bit different because there are fees related to those asset-backed accounts, similar to how you would see fees from your financial advisor for your investment accounts. The investment account options are kind of cool because you can choose what level of risk you want to be in. So there's a conservative growth option, a moderate growth option, and then an aggressive growth option. Enable says that if you want to use the investment option in general, regardless of your risk level, you're usually looking at holding that money for about 5 years. So we're not looking at about transactions or the use of that money unless the time horizon is beyond 5 years. I think that savings accounts may be similar in timeline to that, but both the checking and the savings options are interest-bearing accounts under the Enable program. So checking, as attractive as it is, and I would even consider using it for my own wards instead of having a separate guardianship account, we are actually not able to use the checking account option in Nebraska right now. And this comes from a restriction that we all have on our letters. We've talked about this restriction previously in other topics, but there is a limiting section at the bottom of our letters, which says, among other things, you are not allowed to make cash withdrawals from an ATM or get cash back on debit transactions without a court order. Unfortunately, a census, which is the kind of clear backroom operations management, who handles a lot of retirement accounts, and including Nebraska's Enable account, they interpret that restriction differently than I think the intention is. Well, I know the intention is, and how it's interpreted in the legal community. On the guardian's letters, those are restrictions to the guardian. So it's the fiduciary who is under the obligation to not use the debit card in the ATM and get cash back without a court order, or similarly use a debit card in a transaction and get cash back. That's my responsibility. It would be a violation of my appointment to do so unless I had permission from the court to do so. But more and more banks, and not just Enable, but more and more banks in Omaha are now interpreting that to mean that it's a restriction on them, and that they have to somehow guarantee that the fiduciary is not going to be making these transactions that involve cash. And they say that's way too much liability for us. We don't want to do it. We're not going to issue debit cards. For example, First National Bank will not issue debit cards on a guardianship account. And Enable is taking a similar position in that limiting language prevents guardians from using the checking account function or the checking account feature of these types of available accounts for them. One of the things that I want to do, and I'm not sure if all of you know this, but in 2019, right before the pandemic kind of shut everything down, I was appointed to the Supreme Court Commission on Guardianships and Conservatorships. And of the commission, there is a subcommittee that deals with the drafting of these forms, including the letters that have these restrictions listed on them. And it's my goal to go to the forms committee and say, look, we need to change this so that guardians and conservators in Nebraska can use this checking account option. If I can get that changed, or at least push towards a change like that, it may be the type of thing that you can consolidate everything into an enabled checking account. So that would even include potentially direct depositing SSI money into that account so that you don't have to have two separate accounts. Wouldn't that be wonderful? Now, in talking to Ms. Stewart yesterday, I learned that the IRS has changed the definition of ownership, and now ownership can include representative payee. Nebraska has not adopted that change quite yet, but it might be coming. And right now it sounds as though it's up to the guardian as to whether or not they want to deposit Social Security benefits into an Enable account. I wouldn't recommend doing that at this particular time, obviously, because we don't have the ability to open a checking account. But once these things come together, we can get the letters amended, we can get the checking account option open, and we can get some guidance on whether or not these funds can go into the account and can be opened by a representative payee. That would make so many problems go away, and some of these things would be so seamless. Can you imagine doing an annual report where all you have is your one account, and you don't have to have a separate guardianship account, a separate Enable account, and do accountings for all of them? I personally think that it would be wonderful. I'm going to look at the chat really quick to see if there are any questions. What is the difference between accounts for a disabled individual and a guardian? A good question in the chat is, do you have to get permission from the judge to open an Enable account? No, you do not. However, if you have a budget, you may have to get permission to deposit money into the Enable account in some sort of frequency. Generally, when I have a budget, I'll put a line item in there that says X amount of money is going into the Enable account per month. Usually when I'm dealing with somebody who has SSI, we're talking about maybe $100 a month, which is an okay contribution based on the limits for the account. For a minor child, age 18, am I authorized to open online? Yes, you are. You are. So if you are the parent or guardian of a minor, you are allowed to open the account online. It's only guardians and conservators and powers of attorney for adults who have to use the paper application. How much SSI is generally available for someone 21 years old? Well, SSI, true SSI this year is 793 or 791, 793 per month. Let's talk just a little bit about funding the account. And funding is a term that lawyers use a lot. And I think we use it and we forget that people might not know what we're talking about. When I first became a lawyer and people talked about funding trusts and funding this and that, I confess, I really didn't have any idea what they were talking about. I knew enough that we were putting money into the vessel. That's what we were doing. But beyond that, I had no understanding of what they were referring to. So when we talk about funding the Enable account, it's just a matter of opening the account. The same way that you would go to a normal bank, you'd say, I want to open up a checking account, and they would require some type of initial deposit. So we fund the account with some type of money. One of the ways that we can do that is by using first-party funds. And first-party funds would be the funds of the disabled individual. That is a wonderful thing that Enable allows, particularly after November 2019. So before November 2019, when you had funds in an Enable account, whatever option you chose, checking, savings, investment, it didn't matter, there would be what was called Medicaid recovery at the conclusion of the disability participant's life. So any money that was remaining in the Enable account would go back to the state to reimburse them for the Medicaid benefits that were paid on the disabled person's behalf. One of the problems with how we preserve funds for a disabled individual deals with what we do with their own money. So prior to Enable, and I'm talking about Enable 2019, because my answer would be, or 2020, David, this was your job to correct me. November 2020. Prior to November 2020, I would have talked about this in an entirely different way. And actually, maybe that's better that I start there. So before Enable, if somebody had a disabled participant who had money in excess of the resource limits, whether it was $2,000 or $4,000, they either had to put it in a special needs trust or they had to spend it down. When we're talking about people who receive $793 per month, we're not usually talking about excesses in an amount that would necessitate the opening of a special needs trust. But sometimes you'd have an excess of funds, like, well, let's say someone was in a car accident and they received a personal injury settlement, and now someone who is disabled, and I'm not talking about the accident causing the disability. Let's say that somebody who was already receiving SSI, was already receiving Medicaid benefits, was in a car accident, and they received a personal injury settlement, and now that $100,000 was going to affect their ability to stay eligible for these programs. The only option would be to put the money into what's called a self-funded special needs trust. And when you do that, the state of Nebraska says, well, that's fine, but you have to make us a remainder beneficiary to that trust. So you can use it to supplement your needs throughout your life, but it's going to come back to us when you die. And that's different than third-party special needs trust. But now that we have Enable, particularly Enable after November 2020, the Medicaid recovery provision has been removed. So that's why Enable is such an amazing thing for guardians and guardians of disabled individuals, because now we can save money and we don't have the Medicaid recovery that we had before. There was Medicaid recovery on Enable accounts previous to November of 2020. And one of the things we were talking about as a team today is, you know, what makes an Enable account more attractive than a special needs trust, sometimes also called a supplemental needs trust. And I know, David, you were looking at that and you had some things to share.
Yeah, so in addition to not having the Medicaid recapture anymore, there's two other advantages that Enable accounts have over special needs trusts. The first, we've already talked about this to some extent, is just the familiarity for people working with it. Unlike a special needs trust, you don't need to have a trust document drafted. You don't need to have a trustee serving. It's just like the accounts you already use, your checking and savings accounts. And they can be set up really easily, as I'm sure many of you have already found out. And the other advantage is that the qualified distributions you're able to make for them are really much more liberal than they are under the special needs trust rules. So, for example, you can use the enable funds for food and shelter expenses, which you can't do under the special needs trust rules.
Do you think too that there's some impact to the amount of money that we're talking about? I mean, I think that as a guardian, I'd open an enable account if I had an extra $1,000, but I wouldn't pay an attorney $3,000 to $5,000 to create a trust for that amount.
Yeah, definitely.
So when we have first party funds that we want to protect from Medicaid recapture, and we're within the total that is allowable for enable, which is $100,000, and I'll talk a little bit more about that in the next slide. We can put that money into an enable account and not deal with the Medicaid recovery that we used to have to deal with outright. Now, there is some concern with how this is being set up, and I'll talk about that in a little bit. But for funding the account, we can use the disabled person's money to fund the account, and it can be in an amount that doesn't exceed $15,000. The cool thing is that other people can also contribute to an enable account. So Christmas money, graduation gifts. I was talking to a client who was in my office just this week, and he was talking about how his advice for new guardians is don't start behind. You need to start at zero, because when his son graduated from high school, he already had $1,800 in his bank account because he got all these graduation gifts. So when he became guardian and he got SSI for his son, he was already $200 away from the resource limit. So having the enable account set up from the very beginning to put money into to alleviate yourself from getting close to those limits is a really, really valuable thing. And something that could have been avoided had the account existed before that is the graduation money could have just gone into the account. So gifts, inheritances, anything that someone else would want to leave or gift can also be included in that $15,000. And the $15,000 is for 2021. It's relative to the gift tax exemption, the annual gift tax exemption, which for right now is 2021. We're still not quite sure how those tax exemptions are going to change under the current administration, but for right now, it is $15,000 per year. There is a slight exception to the contribution limits when the participant is working and they're earning their own income. That can be raised a little bit, but just know that we don't need to get into the details of that right now. Just know that that limit gets adjusted for them. Okay, so I said there were one of two slides that were really important. This is the second slide, because I think that when people talk about enable, they really want to know what we're talking about and how to use the money. So David spent a lot of time looking at permissible expenses, and he wants to tell you about those right now.
All right. Well, I am honored to have the privilege of handling one of the most important slides today. So permissible expenses are expenses for supplies or services related to the account owner's disability that assists them in increasing and or maintaining their health, independence, and or quality of life. So it's a pretty broad definition, which is nice. So as you can see here, we have a lot of different categories here. There's education, which can be tuition, books, supplies, housing, your rent, mortgage, utilities, repairs. There is a caveat on the housing though. Housing expenses must be spent within 1 month of distribution, or else they'll be counted as a resource for Social Security. So there's that to keep in mind. Food, which can include groceries, takeout, fast food, transportation, your mass transit like bus passes. You could even do Uber and Lyft, any kind of vehicle repair modifications. Employment training and support. This could include classes, counseling, assisted technology and related service. There's a wide variety of things this could be. Some examples would be electronic communication programs to help the disabled person communicate with others, hearing aids, personal support services, kind of along the same lines. Many things this could include. One example could be service animals to help that person out. Health, prevention, and wellness, medical, dental, vision, mental health, medical equipment, rehabilitation, long-term services. Also financial management and administrative services, legal fees, which could be like an employment of an attorney for helping you with your guardianship annual reporting. The fees for your Enable accounts that JT was telling you guys about earlier, funeral and burial expenses, and then just as a catch-all, other expenses to enhance the account owner's life.
Thank you. We have a couple of questions about my prior slide, so I'm gonna go back to those. Okay. One is the 15,000 per year, and that's the total. So I think what we should talk about is what's allowed in the account. And a lot of people explain this incorrectly. The account can have $100,000 in it, and that's disregarded as a resource for Medicaid and Social SSI benefits. The account itself can hold more than that. It's just that it's counted, the excess is counted as a resource. And as long as the account is over the disregarded amount in such a way that the total resources are disqualifying. So that's like everything. So let's say there's a guardianship checking account that has $1,000 in it. The Enable account has 100. Let's say it's got $100,000 and then $2,000 extra. Well, 100,000 is disregarded, but now between the guardianship account and the excess in the Enable account, we have $3,000, which is too much for SSI. So until we got back down to the $2,000 SSI resource limit, we would be disqualified from SSI benefits. Part of what I think people explain incorrectly is they say the account can only have $100,000 in it. Well, that's actually not true. It's not like Enable is going to send a check back to say, you send us too much money and we're not allowed to have it. They don't govern that. That's your responsibility. So it's important to recognize that the first 100,000 is what's disregarded, and anything in excess of that could potentially be considered a disqualifying resource if the total of all of your resources are in excess of the limits. One of the questions in the chat is, can we explain the $2,000 limit level on the Wards account? We would spend the money. Okay, there's several questions. I'm gonna take them one at a time. So can I explain the $2,000 limit level on the Wards account? So $2,000 is what SSI recipients are allowed to have in total assets in order to maintain their eligibility for the supplemental Social Security income. If you get beyond that, you lose your eligibility for SSI benefits. So there are different resource limits depending on what program you're on. Earlier, I was talking about Medicaid, and the resource limit for Medicaid is $4,000. So the second part of the question is, we would spend the monthly amount until there was suddenly a stimulus payment in the account. And stimulus payments, are obviously new to all of us because we didn't have them before the pandemic in 2020. But the stimulus money presents a perfect example of how Enable accounts can be beneficial for someone who's under a guardianship or a disabled participant. Don't worry about the Enable money, or don't worry about the stimulus money being in a guardianship account until it's been there for 12 months. So it's not counted as a resource until you haven't spent it for 12 months. But once you reach the 12-month mark, then it becomes a countable resource. And getting it out of the guardianship checking account is what you want to do. You either can spend it down, or you can put it in a self-funded supplemental needs trust, which we wouldn't want to do, or you can simply open an enable account, which would be the advisable thing to do to save that money and then use it for the permissible expenses that David was just explaining. I do have a budget plan with the guardianship. I know that we were over 2,000 at one point in the month. In terms of total balance, I think that's what you mean, is in terms of total balance, you were over $2,000. Yes. Well, you know, my experience with overages like that have been that you'll get time to spend the money down, but you have to get it out of the account as quickly as possible. So, you know, in my Medicaid application or my Medicaid renewals, you know, they might see a bank statement where there's a fluctuation like that, where at one point in time, because the rent check hadn't been cashed, the actual account balance was over. So they monitor the picture over a period of time. So it wouldn't bother me that the account for even a brief period of time was over. It's just when it stays over is the problem. My ward is receiving Social Security disability benefits instead of SSI. He is also on Medicaid. Does the 4,000 max or the 2,000 max apply to him? Excellent question. 2,000 applies to SSI only, but he would still be on the $4,000 limit for Medicaid. That's a standalone resource limit. The question is, do we really need to send our annual reports to all interested persons, including siblings and the Social Security Administration? Have you dealt much with interested persons?
Say that again.
Have you dealt much with interested persons yet?
I've had to do some statutory research, and definitely while sending out notifications to families that have a ward or incapacitated person involved. So the notice is going to the interested persons. It's pretty important, and it gives a good oversight. So basically everybody can have eyes on what is occurring with the ward in their circumstances and with their financial status. And this can be useful to prevent any kind of financial abuse or anything like that.
I think there are a lot of complaints about how paper heavy guardianships are. And one of the ways that they become paper heavy is when you have to send everything out to interested persons. And it especially becomes really ridiculous when you have interested persons who are like within the same household or are family members who frequently see one another. A question I get all the time is, you know, do I really have to mail this to my daughter? You know, I'm going to see her on Sunday for dinner. And it's an annoying thing, but it's a required thing. Interested persons are not optional in terms of notifying them of things within the guardianship or conservatorship. Now, in April of 2020, the new rule says that interested persons can waive notice of certain things. So your annual report, they can waive notice of that, for example. Your applications for attorney fees, if your attorney's seeking fees from the guardianship estate, or if you're seeking reimbursement, they can waive notice on those types of filings and hearings on those types of filings. But for everything else, they're required to be notified. And we really need that because no one else is monitoring the guardianship case. And I know that some people are going to kind of laugh at that because they're going to say, Molly, I just got called down to the court by the auditor because they wanted to know why I spent $11 at Sonic. I get it. I get it. I've been there too. For those of us who are responsible guardians and take our duties very, very seriously, this stuff does seem totally unnecessary. But there are 10,000 guardianship cases across the state of Nebraska, and not everybody has somebody who loves them, taking care of them. The interested persons are there by design so that you can have someone who's outside of the court process watching what the guardian is doing, particularly with the money, to make sure that nothing is happening that shouldn't be. Many, many years ago, a woman was indicted federally for having stolen, I don't know, like over 6 figures worth of money from her 600 wards. And when that happened across the state of Nebraska, 600 people were left without a guardian, a rep payee, or whatever decision maker she was for them. And because of that one woman's decision, there's been a lot of overhaul that now puts more of a burden on us to do reporting and notifying. And it never used to be that way. And it's unfortunate because of someone else's bad acts that we now have to get involved in these paper heavy things. But it is something that is meant to protect the rest of the population. And so I would just really encourage you to think of it as an opportunity to protect somebody else who's vulnerable. So when it's annoying to have to make copies and mail them out, when it's frustrating to have to give documents to people who are calling you up like, Mom, why did you just mail me this? Just think of it as an extension of the appointment that you already accepted to help someone else who's in the same situation as your child or your parent or your sibling or your friend for whom you're now making a decision. I know that when I think about it like that, it becomes easier for me to get involved in the heavy paperwork that's otherwise kind of a burden. Another question back on Enable is, are we required to include Enable account balances within the annual report and when we renew for Medicaid? I'm going to talk about those two things separately. So I've been kind of doing a new thing in my guardianship cases. For my clients, when there are two different accounts, a checking account and an Enable account, I take the position that because the Enable account is restricted by its own terms and you can only use the money for qualified disability expenses, that it's sort of like a self-governed account, almost like a special needs trust where there's a trustee governing the money. I have been successful in excluding Enable accounts from annual accountings because of that argument, which reduces the accounting burden for my guardians a lot. Now, if we are able to consolidate all of our accounts into one checking account under Enable, I don't think that would be my advice. But I don't know that for sure because I don't know what that landscape will look like. But I do currently take the position that it should be excluded from your annual report because you don't have discretion over how the money is spent. I mean, to some extent, you get to decide whether to use the money for education or housing or an attorney. But beyond that, you don't have the same level of discretion to just use the money the same way that you do from a normal checking account. But here's the thing. I always get permission to exclude it. So I don't just decide to exclude it. I'll ask the court for a specific court order allowing me to exclude it from future accountings. And I've never had a judge tell me no on that. So that's something to think about if you're feeling like the accounting piece is too much and you have too many accounts to report. Now, right now, I don't know how many transactions there would be on a savings or an investment account, but it is something for you to consider. Another question is, and I'm going to let one of you guys take this. I don't care which. Social Security SSI rules don't allow parents or others to help support the SSI recipient without having the recipient losing some dollar for dollar SSI benefits. So can I, as a parent, deposit money into my daughter's Enable account with the express purpose for that money to be withdrawn later and help pay for part of my daughter's monthly apartment rent or utility bills at the apartment, etc., without the deposit or withdrawal violating the SSI rules? My daughter's SSI and SSA monthly benefits are not enough to cover her rent and utilities.
Yeah, based on the research I did for the permissible expenses, you should be able to take that money out of the Enable account to pay for those housing expenses. But like I said, you just have to make sure that that expense is made within a month after you take the money out of the account. If Social Security finds out that that money's still there more than a month later, it'll go against your allowable limit.
All right, I'm gonna move on to our next and last slide, and I'm gonna talk to you about the but. The truth always comes after the but, right? So enable is a wonderful thing. How you want to use the enable account in terms of a checking or a savings or an investment option is completely up to you. I would encourage you to talk to an attorney or a financial advisor to determine what you think would be best based on, things that are kind of unpleasant, but like life expectancy tables, to try and figure out what the options and what the needs might be for an individual as they're aging, for a disabled individual as they're aging. So that's wonderful. Having $100,000 in the account tax-free is also wonderful. Having no Medicaid recovery for the account balance at death is also wonderful. But here's the but. In November 2020, when LB 705 passed, which removed the Medicaid recovery provision for these enable accounts, it gave us two options for what to do with the remaining balance in an account. The first one is being able to roll it over into another enable account or another able account in another state. You can also leave it to the disabled participant's estate. We don't know as a firm right now if separate Medicaid recovery rules would then attach to the estate and get the money anyway. So we're in the process of trying to find an answer to that question. And if the answer is yes, then what potential options are for our clients to avoid that or prevent that or mitigate that in some way. And that's the but. So it's possible that once the money leaves the account, and I read the legislative bill and the statute, and it's clear that when the money stays in the account, it will not attach to Medicaid recovery. But the question is, once it moves into an estate that's being probated, is there Medicaid recovery there? Because there is Medicaid recovery in estate proceedings. And so we're going to find out an answer on that. We might even do a separate webinar on that to talk about that. But most enable accounts don't have $100,000. So at this point, I would not let this be something that prevents you from opening an enable account. Obviously, if you're going to fund an enable account to the max, maybe wait until we get an answer on this. But on average, I see enable accounts somewhere between like $2,000 and $20,000. And not that $20,000 is a small amount of money, it certainly isn't, but it's closer to the $2,000 mark on average that I see. And at one point, I think I knew what the average account balance was, and I'm losing track of it, but I think it was somewhere around the $2,000, $2,500 figure. David, do you remember what that was? We learned that in a previous webinar we watched about Enable several months ago. You don't happen to remember that, do you?
I don't.
That's okay. But the point anyway is that most accounts don't have so much money in it that they become undesirable because we don't have an answer to this question. So we're going to find out the answer to the question surely and see what options we have. I don't know that the rollover option is something that's going to be viable for most people, because that would require another member of the family to also be a qualified participant in the plan, which is possible, but just unlikely. So we will find that out and figure out what options are for people in terms of Medicaid recovery at the estate level. But we're watching it. We want to make sure that we're not giving bad advice about Enable. So we want to get an answer on that, and we will do so.
Thank you again for your download. Each purchase you make on Guardian Connect enables us to provide more resources and more education for caregivers just like you. On behalf of the entire Guardian Connect team, thank you.